recorded.
Good afternoon, everyone, and welcome back to a special episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluate. So, as I said, this is a slightly different podcast to our usual run-through of news stories. So, just by way of an introduction, I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and Peter, I'll let you introduce yourself, and we will dive right in.
My name's Peter, I'm a solicitor and managing director at Digital Law. And indeed, this is a special episode all about encryption due to the news-worthy nature of a few developments in the UK in particular, but I think it's worth highlighting a few issues around the importance of encryption as a whole. So that's really what we'll be discussing today. So I'll pass back to Amelia to start off.
Thanks, Peter. So you may or may not have seen in the news a big story about Apple and the fact that Apple is taking unprecedented steps of removing its highest level data security tool from customers in the UK after government demanded access to user data. So this is quite interesting for us because obviously within our sphere, we are talking all about data, and very often we're talking to our clients about data and encryption. And Peter, I'll pass over to you in terms of just outline a bit of context here.
So very often we'll get, and even this comes down actually to, in particular when it comes to us as a law firm, talking to our clients in a secure, confidential way is actually more difficult than you might think. Very often we'll get people say, oh, can we speak to you on WhatsApp, or can we share a document via Google?
Or Telegram, that's another one that's coming out of the woodwork.
Indeed, and the answer to that is always no, and definitely not. And the reason for that is that while some of these systems may say, oh, well, we have various levels of encryption and security in place, they aren't necessarily entirely secure. So just because something says, oh, we have layers of encryption around it, does not necessarily mean it is secure, because who knows who can be added. How often have you been on a WhatsApp group and you've not necessarily known how many people are on that chat? In particular, where you get these sort of legacy groups that are set up for stag and hen weekends and big weekends and social plans, and then suddenly they're still there rumbling away in the background, and you might not necessarily know who's on there. And the point is that sometimes you find that people are added to these groups that you may not necessarily be in control of. So is it probably something that you're sharing with a client, or have others been added to it that mean that what you're providing is no longer secure? You can go down a similar path when it comes to Google in terms of documents being shared, who has the rights to view them, who has the rights to edit them. It's not a tool that's derived for the provision of legal services. So, for example, for our clients, we can share documents through a very secure tool designed for law firms. It is highly secure. We have instant messaging with our clients, again, through a highly secure third-party portal, not a free commercially available one like the aforementioned WhatsApp. So, therefore, the security of communication is really key. Also, bear in mind that what we're going to talk about here in terms of Apple doesn't mean that, for example, if you're on an Apple device and you then send a message to another user of an Apple device, that's not just sent between you and the individual. Sometimes, depending on the platform you're using, that might be kept on a third-party server, like, again, WhatsApp. That's how it works, that when, for example, on your phone, if you reconnect, or on a new phone and you connect to your WhatsApp account, that's how it's able to repopulate all of those old messages. It's doing it from the third-party server. If you've just got secure encryption between you and the other user and no third-party server, you lose all your messages, which is what happens with Signal. So, for example, that's just secure between you and the other user. If that communication is interrupted, that's it. It's gone. There's no sort of backup in terms of securing your data and your messages going back. Which I think, again, makes you actually a bit more conscious of how you're sharing information. You're knowing that this might not be a sort of forever nature that you're sharing this, and it will have a finite lifespan, and it's based on how long your mobile device lasts.
So that's kind of an overview in terms of how encryption applies here. But going back to the story about Apple. So earlier in February, the Home Office under the Investigatory Powers Act, the IPA, they went to Apple and asked for access to their information. So essentially, the IPA compels firms to provide information to law enforcement agencies. Peter, are you able to provide us with a little bit of background on what the IPA is?
So, the IPA is not India Pale Ale. It's actually the Investigatory Powers Act, which is a piece of legislation that actually dates back to 2016. It is the piece of legislation that governs how the UK government security services can carry out surveillance. There was actually an awful lot of lobbying around the creation and introduction of this legislation because it was so controversial at the time. A lot of the argument at the time was around things like bulk surveillance, whereby security services might say, we want to see all the information related to all of the mobile devices or all of the devices that a particular tech giant may have, say, for example, Apple or Android, in, say, about 4 postcode zones. So if, for example, there's a terror threat and they think, oh, we want to be able to see where mobile devices are or what's on certain devices, the idea is that you could get these bulk surveillance warrants that would be signed off by a judge or a retired judge at the time. But nonetheless, there would be this sort of judicial lock on there that would mean that it's not just the security services saying, we want this and demanding it. There was a clear process designed, and that was signed off by Parliament in 2016. But it's a very big piece of legislation that draws together an awful lot of rights in relation to what government can ask. And where we're saying government agencies, we're talking here about, for example, GCHQ, the government's combined communications surveillance post at Cheltenham. We're talking about the police, we're talking about MI5, MI6, military intelligence. We are talking about the various sort of national criminal investigation agencies. Because increasingly mobile phone communications form a key part of how the certainly domestic prosecution services will seek then to build a case based on location data, GPS data, messages that may have been exchanged. That data very often underpins now the basis for a successful criminal prosecution. But furthermore, if you're looking at suspected terrorism and terror cells, obviously it's incredibly important where they think there could be a just reason to carry out this sort of surveillance. Then security services may say, well, we need to do this in order to prevent a major terrorist attack. But as is always the case with these things, how far do you go? In order to keep us safe, how many of our liberties do you have to take away? And this is the awful situation.
Well, that's just it. So Apple at the time would not comment on the notice, and the Home Office refused to either confirm or deny the existence. But more recently, Apple is deciding to take the unprecedented steps of removing its highest level data security tool from customers in the UK after this access was demanded. So we're specifically talking about the advanced data protection. So ADP means that only account holders can view items such as photos or documents that they have stored online through a process known as end-to-end encryption. But essentially, Apple have said that they are not wanting to create a backdoor into this, because when creating that backdoor, you create a weakness that can then be exploited. And this is kind of the sticking point here.
It is, but actually, funny enough, my reading of that was that actually it's pretty much impossible to create a backdoor into this system. And that's why Apple have done what they've done.
Okay.
It's not like they can say, oh, well, we can keep this in place and grant access to the UK government. They've basically turned around and said, well, we can't do that, so we'll just have to get rid of it. It's almost like, so they've literally said, well, in that case, because if the UK government wants to have this access, we will have to remove advanced data protection, i.e. high-level end-to-end encryption, for all of our UK users. So they basically said, it's not as though we can engineer some magical backdoor. They certainly can't do it within probably the time frame the security services wanted it in.
Yeah.
Therefore, they've just said, well, okay, well, we can't remove it in one case. We'll have to remove it for everyone. So they can clearly do that on a geographical basis. They can say to all Apple users with an IP address in the UK, they're saying that's it now, you can't access this feature.
So I will add in here the fact that actually, so if you are a new user, you are no longer able to access advanced data protection within your settings. However, if you are an existing user, the service will be going ahead for now. However, this will eventually be scaled back. And it is also worth noting the fact that data with standard encryption is already accessible by Apple and shareable with law enforcement if they have a warrant. We're specifically looking at data that's stored under that advanced data protection here.
And that's just it. That's clearly it's been possible so far to walk a narrow tightrope whereby advanced data protection end-to-end encryption remained in place, and specific warrants that were requested, probably for very targeted specific means, were being serviced by Apple. It is worth saying that the majority of tech platforms do respond to those warrants where issued under the legislation, and that goes the same for Twitter, Meta. Even though these companies will very often make a big deal out of free speech and privacy, they'll very quietly have been complying with warrants issued under the clear statutory basis under the Investigatory Powers Act in the UK. The point here is that for whatever reason, a request has been issued that falls outside of that sort of narrow envelope that allowed them to be able to provide whatever information that security services particularly wanted previously. Now, whatever it is they're asking for cannot be provided using that previous envelope. Whether we were looking at broader surveillance, whether we were looking at a richer type of data, it almost sounds on the basis of it, that almost like the government saying, well, we want very broad access to all Apple users, almost. It seems that is the only thing that could have warranted the abandoning of this entire encryption mechanism.
And that's just it, actually, because in theory, the IPA does actually exist across the world, and that can therefore be used by the UK government to question potentially data subjects in the US if there's warranted reason for that. So while Apple have taken this stance, it's like, okay, well, that applies to the UK, but what about, should we request this of another data subject based in a different country outside the UK? So does it go far enough to then comply with the Home Office's request?
And this is just it. It's an increasing thing. You always used to have the basis that laws applied in a specific jurisdiction, but along comes what in effect is the global digital economy. And therefore, increasingly, you have legislation which has extraterritorial effect. So, for example, an awful lot of data protection legislation now doesn't just apply in a jurisdiction. It basically says, well, this legislation applies to all of our data subjects in our jurisdiction. But if a corporation based overseas is collecting the data of our data subject, then our laws will apply to that company. So this is a sort of principle that was introduced under the General Data Protection Regulation, and is also then baked into the UK Data Protection Act, and is echoed here in this security legislation, saying, well, this can apply outside as well. And increasingly, there's US legislation that in some instances is being applied overseas as well, when it comes to, for example, US corporations like Meta, Amazon, Apple, that have significant infrastructure in countries like Ireland to comply with Europe's data protection requirements. Increasingly, the US has been turning around saying, well, you are a US corporation, you are domiciled in the US for tax purposes, therefore, if our courts say you should provide something, even though you're located in a third country, and even though the data you're processing is of data subjects who are not US citizens, we are going to demand that you provide us access to that. So we've had this interesting sort of growth of that sort of extraterritoriality of these laws in recent years. And that's a very good question. Will we potentially get, at the moment, this is just a UK thing that's happened. And Apple hasn't pushed back. It's just said, well, okay, we'll switch this off in the UK. Would they push back? And would other governments in other countries push back if the UK were to say, well, we would now want to have access to whatever data outside of the UK?
Well,
That's an interesting question.
You make a good point there, because actually within this article, 2 senior US politicians said it was so serious a threat to American national security that the US government should reevaluate its intelligence sharing agreements with UK unless it was withdrawn. So when you've got this kind of this stance in the US here, it does make you think a little bit more about how this IPA law can actually affect extraterritorially, as you explained. And I think it'd be quite interesting to see whether, we've seen Apple being hit there. Could we then be looking at similar thing with Google and Google related devices, because they are equally one of the other big players in the game? Or furthermore, Samsung, or, you can see where we're going with this.
Or Meta with Messenger, etc.
Yeah.
And the question here as well is, that quote where it's said, 2 senior US politicians have questioned data sharing between the US and the UK. What they're talking about there is the Five Eyes network, which underpins global intelligence sharing between the United States, Canada, the UK, Australia, and New Zealand. If you had data sharing between the US and the UK stopped or jeopardized through that, the security of that entire network, which underpins Western defence, would be compromised, because a large part of it, one of the few things that the UK actually contributes in a significant way, sort of punches above its weight, is its intelligence, surveillance, and interception, i.e. the sharing of surveillance from GCHQ to other Western security agencies. If this should compromise that is quite a major issue from a geopolitical stability point. But we're moving away from the discussion around encryption, but I think it's an important point to make, because sometimes what can seem like small administrative moves like this can have major consequences in terms of then the relationships between governments and the ability of governments and agencies to work together. In that you've got their relationships that have been in place for decades, going back to the 1940s, that could be irrevocably changed just through warrants being issued here under the Investigatory Powers Act and the response from a US tech firm to that.
And you might ask, well, why is it suddenly happening now? And I think it's because there is, as we've covered in other podcasts, the issues with kind of children and the sensitivity of sexual content that is being shared online via potentially messaging platforms. And that's one of the main points underpinning some of this access as well. Because I know we've talked about terrorism, but it's actually looking at cracking down on other forms of criminal enterprises that can occur through the use of encryption that is obviously clouding those people's identities. And so this is another point where they're trying to, this is something the UK government is trying to crack down on through the IPA, as you said. But it does leave as well, if you're thinking about, okay, well, with this request, Apple have been targeted. But if you have then got a company that will turn around and say, okay, fine, we will create a backdoor. That backdoor is a weakness, and a weakness like that can be exploited. And in some instances, quite easily, particularly when we have got, at the moment, critical infrastructure being targeted by nation-state actors. If you, for example, Russia turned around and said, oh, we know X has put a backdoor into their system, we're going to target them to take down X, Y, and Z. You've got quite a big problem.
Yes, is the short answer to that.
Yeah.
We know that both, it was only a couple of months ago that Chinese state surveillance of UK security infrastructure was a problem. And there were major reports about this during the Christmas period.
Right.
So it was only 2 months ago we're talking about these sort of security threats, and now we've got an issue like this coming up. So we know that there are significant, quite powerful nation states out there with very well developed capabilities when it comes to aggressive cyber threats. And by taking away this advanced security, this means that communications between Apple users, without them being encrypted, if they are intercepted, they can therefore be read far more easily.
But it's not just communications as well. You've got it's anything that can be stored in the iCloud. So it could be emails, it could be documents, it could be photos. You've not just got the data of messages, you've got quite a rich data set there that can then be monitored, used, surveilled.
If we go back to what we were discussing at the top of this discussion, we were making the point that when it comes to an awful lot of communications using traditional platforms like Apple, WhatsApp, etc., we, digital law, end up advising our clients, do not use these for business-related purposes.
Yeah.
In particular, if you have a professional duty of confidentiality, so if you are in law, or accounting, or medicine, or certainly under the Financial Conduct Authority has got quite draconian in recent years with regards to calls with regards to banking and financial services. They'll say, oh, certain calls with regards to banking investments have to be recorded, but then you'd want to have them recorded securely so that they are not freely available for anyone to potentially listen into. This raises a whole list of questions with regards to security and privacy of personal data. And therefore, we would in the past we'd have said, well, don't use Apple anyway, but many organizations have continued to do this. Many law firms, many companies with those professional duties of confidentiality have ended up using Apple because they're not known to do anything else. But we're now in the situation whereby if those messages were intercepted, they could be looked at, and therefore things like confidentiality, patient confidentiality, etc., could be easily compromised.
And also, obviously, this story is focusing on Apple, and this is the first kind of big request that has come out under the IPA. But what's to say that potentially in the future down the line, we could have other similar requests if you're looking at Google or Microsoft? So it's what sort of precedent that this is looking to set.
Exactly.
Because, yes, while this typifies the point we've been making about encryption, this is very much a short-term, case. Whereas thinking more long-term and how it could affect other users, other organizations, we could see quite a dramatic shift in a hierarchy of standards of encryption that are then being applied.
Yeah, I mean, there were some revisions to the Investigatory Powers Act made last year, and for a time there was some excessive lobbying made by a number of platforms, including Signal, Meta, Apple, who were not happy about the way some of the powers were worded because they were concerned of issues just like this. And a series of assurances were given by the government at the time, and as well as sort of amendments and changes to the legislation, how it was going to be worded. But this actually also highlights some of the problems that come in where, of course, one government can put these laws together. And don't forget, the Investigatory Powers Act was a creature of the Conservative government and indeed the coalition government from 2010 to 2015, where a lot of the horse trading and drafting was carried out, and then 2016 when it was actually passed under. So that was, by that point, I think it was a mixture of the certainly the David Cameron government did most of the work on that. We've then got most of the lobbying since then on these amendments that were then carried out in 2024 and agreed under the Rishi Sunak government. But of course, that is one government giving various assurances, and then we're now over 6 months into a Labour government. And this shows the fact that a new government can come in, take a look at a law and say, well, that's great, but on our interpretation of it, we're going to do this.
Yeah.
And do something totally different from what was originally envisaged. So I think, whereas in 2024 we had an awful lot of these tech firms almost breathing a sigh of relief at the time and saying, okay, we are content that the powers contained in this law will not compromise the way we deliver our services to our users. But that now, following a general election and a new government coming in, those assurances and confidences have pretty much been blown to pieces. And indeed, now on the back of this is Apple. Will we see something similar happening with regards to Meta, with regards to WhatsApp, with regards to Google?
I think that's interesting. I think one of the main things as well that I've neglected to mention here is the fact that obviously these powers are not going to just be used on every single individual. It's not going to be saying, well, every single individual is going to be monitored. There's still going to have to be a level of reasoning to be able to say to Apple, look, we want to see information on this data subject. But, and then there's a but, and Peter, I'll let you come in.
No, you finish your thought. You're there. You can't keep going. Go on.
But it just leaves the door open to massive agenting. And that's where I was going. But Peter, did you want to?
Well, no. So it's the fact that even though we aren't looking at everyone's information being surveilled by the government, they're probably only wanting very specific and limited information on a small number of users, probably quite targeted. It is because of that, it's almost ruined it for everyone.
Yeah.
So everyone's data is less secure on Apple. Everyone's data, if intercepted, can now be accessed far more easily than was the case in the past. Hackers in the past would not have bothered because they would have known that Apple's data since 2022 was secure behind the advanced data protection, encrypted end-to-end security. That's now gone, so now they'll go, oh, well, actually, it might be worth having a good look at Apple users. It is
worth mentioning that the ADP was on, you had to sign up for it. So, it's not to say that every single person that uses Apple will be affected, but certainly if you are an individual that has signed up to this ADP service because you want a higher level of encryption, that's just going to be taken away. If you are an individual that was using ADP and using that service because you had high standards, for example, and confidentiality, then that is removing that level of protection that you've relied upon.
Exactly. Though I would advise, as I say, even our previous advice, even with this ADP in place, we wouldn't have been saying you should use it for those purposes. But a lot of people have.
Yeah.
A lot of people have. And that's really why we wanted to sort of have this discussion, sort of make it clear that you cannot, unfortunately, if you are subject to those sorts of professional duties of confidentialities, you now need to think very, very carefully about how you are communicating with colleagues, with clients, with customers, because you are not able to demonstrate you are complying with those professional duties of confidentiality, privacy, etc., when you're relying on Apple services for that purpose. And then watch this space, because you'll probably find that something similar will happen to other platforms as well.
Thanks, Peter. I think that rounds off our discussion nicely there. So obviously that was the main story for today, was looking at encryption. But of course, if you do have any questions about anything that we have talked about today, then please feel free to email us at admin@digitallawuk.com. And a big thank you again to Anson Evaluate for helping to produce this podcast. And I will note that we will be back with our regular news stories and discussions next week. So thank you for listening, and we hope to see you again soon.